Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. We are from TLB 6, KLB 2, are going to present the case review on the power of Islamic Religious Council in controlling publication against Islamic teaching. So, before we proceed to the presentation, let me introduce myself. My name is Nurul Insyirah binti Ahmad Fakhrazi, and my matrix number is 1222164.
My name is Nurul Aimai Sarah binti Muhammad Rizzi. My matric number is 122221455.
My name is Nur Hasliza Fazli Syafiqah Asmadi. My matric number is 1222166.
My name is Tuan Nur Amni Faikah binti Tuan Mahfri and my matric number is 1222169.
All right. Before we proceed to the fix of the case, I would like to explain briefly the introduction of the case. So our groups decided to review the case of the Berjaya Book Sendirian Berhad and another versus Jabatan Agama Islam Wilayah Persekutuan and others. Okay, this case was held at the High Court of the Kuala Lumpur, and the judge panel is the Datuk Salihah binti Yusof J. And this case was decided, or the judgment date is on the 23rd March of 2013. Okay, the applicants of this case consist of three persons or three different persons. First appellant is the owner of the Borders bookstore, and second appellant is non-Muslim, who is Stephen Fong, and the third appellant is Nick Raina binti Nick Abdul Aziz. And for the respondents, the first respondent is the Jabatan Agama Islam Wilayah Persekutuan. Second respondent is Ministry of Home Affairs. Third respondent is the Menteri di Jabatan Perdana Menteri. Okay, so inshallah, I would like to present the facts of the case or the chronology of the case. Okay, basically, the applicants claim for the judicial review as they against the actions by the first respondent, Jabatan Agama Islam, in raiding and searching the premise of the first applicant and seizing publications and examining the first applicant's Muslim and non-Muslim employees, and also arresting and prosecuting the third applicant. Next slide. Okay, so I would like to explain specifically on what happened on the 23rd May of 2012. Okay, 23rd May of 2012, the first responders officers raided the Borders bookstore, and during the raid, the first responder officers seized the several books by an international writer, Irsyad Manji, titled Allah Kebebasan dan Cinta, second, Allah Liberty and Love. So, at the material time, when the first respondent raided the Border bookstore, there is no official prohibition or official restriction order by the Ministry of Home Affairs, but they still proceed to examine the employees and even order them to be further subjected to investigation and examination, although there is no official prohibition order by the KDN. So, on 29 May of 2012, the KDN made a prohibition order, which is 3 weeks after the raid. Okay, on 30 May of 2012, as ordered by the first respondent, the second applicant and the third applicant and another borders employee attended the first respondent's office to assist with the investigation and to be examined. And even though the second applicant is non-Muslim, uh, the second applicant is still subjected to go to the office of the first respondent to assist with the investigation, despite the second applicant is non-Muslim. Okay, on the same day, the third applicant was arrested. So, as a conclusion, the applicants made various representation to all the respondents, but the first respondent still insists that it will prosecute the third applicant under Section 13 of the Sharia Criminal Offences, Federal Territories Act 1997 for the offence of distributing or selling publication which is contradict to the Islamic law.
Okay, so next we're going to move to the issues of the case. From the facts of the case that has been explained by my friend just now, we can conclude that there are two issues that has been emphasized for this case. The first one is whether the High Court have the jurisdiction to hear this application, and the next one is whether the respondent's action against the applicants are lawful. Next slide. Okay, so next we're going to look at the relevant statute provisions. There are a few provisions that has been stated in the case, but I'm just going to state 5 from all the provisions that has been provided. Okay, so for the first one is Sharia Criminal Offences Federal Territories Act 1997 from the Section 13 of Act 559. This provision stated that any publication or any publishing that that violates violate the Islamic teaching or contrary to Islamic teaching, the publisher, the one who owns the publishing or the publication, can be convicted to offences that can be fined up to 3,000 ringgit or imprisonment not exceeding 2 years or both. Next provisions is Printing Presses and Publications Act 1984 from Section 7 Clause 1 of Act 301. So this section stated that if the minister if the minister satisfied that any publication contains something that is contrary to any law, he can prohibit the publication in absolute. Next, we're going to see the provision under Federal Constitution. Okay, so there has Article 7 from the Federal Constitution. Okay, so this article stated that anyone who already has been punished or has been summoned by this article cannot be acquitted for any conviction of an offence. Cannot be tried again for the same offence, except if there has superior court than the previous one. Okay, so next is Article 74 from the Federal Constitution stated that the separation of power between the Parliament and State Legislative Assembly on legislate the laws, which the Parliament can legislate any laws under the item for the state, for the federal list and concurrent list, while the State Legislative Assembly can legislate laws under the state list and concurrent list. Okay, so next provision is the Administration of Islamic Law, Federal Territory Act 1993, Act 505, that stated in this presentation, the meaning of Muslim. Okay, so this simply put that the meaning of Muslim is one person who profess the religion of Islam. And the last one, if you can see the F, the point of F, a person who is shown to have stated in circumstances in which he has bound by law to state the truth that he was a Muslim, whether the statement be verbal or written. Okay, next slide. We also can see, other than the statute provision, we also can see the referred cases related to these Berjaya book cases, the precedent cases, such as the Latifah binti Matzin versus Rosmawati binti Syaiban and another, and multi-purpose holdings Berhad versus Ketua Pengarah Hasil Dalam Negeri, and etc., as we can see in the slide. Okay, next.
Let's move to the parties' argument. Respondent argument basically rely on Act 559 and Item 1 of List 2 of the 9th Schedule and Federal Constitution, and read together with CL2 of Article 74 of Federal Constitution. This is to oppose this application and support their argument to be valid. Next, they also argued the substance of Section 13 of Act 559 in respect of religious publication contrary to Islamic law, covered by Item 1, List 2 of the 9th Schedule of Federal Constitution, so that the High Court has no jurisdiction to deal with this case. Further, they also argued that the action taken by Jawi under the criminal law and not civil law, therefore is not subject to judicial review by this court. However, the appellant's argument argued under Section 17 of the Printing, Presses and Publication Act 1984, Act 301, was legislated pursuant to Item 21 of List 1 of the 9th Schedule and read together with CL1 of Article 74 of Federal Constitution. Therefore, it has superior legislative capacity as compared to Section 13 of the Sharia Criminal Offences, which is only applicable to the federal territories of Kuala Lumpur, Labuan, and Putrajaya. They also argued that Act 559 and other laws pertaining to the administration to Islamic law only applied to Muslim. And they also contended the High Court and not Sharia Court had jurisdiction to review decision and action of respondent, and contended what amount to contrary to Islamic law under Section 13 of Act 559 itself is ambiguous and wide. They argued that the offence specified under the said Section 13 of Act 559, which is a legislation of an offence against the precept of Islam, is a legislation upon religious doctrine, and it is not criminal law.
Okay, next we proceed to whether the High Court has jurisdiction to hear the application. Okay, in the Act of Sharia criminal offence, a law for Muslim, but High Court still have jurisdiction to interpret it. In List 1 of the 9th Schedule of Federal Constitution, provide that Islamic law and other personal related to the law is a matter. Okay, in the matter related to publication, printing, and printing process, well, in the list, in the of the 9th Schedule of the Federal Constitution, read together with Act 74 of the Constitution. Okay, the state could not enact law in regard to matter included in Federal list, even though the state legislature have power to create offense against the precept of Islam. Okay, it is important to inform what kind of the publication are considered contrary to Islamic law to the members of the public. This is because the statement contrary to Islamic law was too wide to understand. To conclude, High Court has clear to hear the application under 053 of the Rule of Court 2012, the question of this court encroaching into the jurisdiction of the Sharia court does not rise at all. Okay, for the second issue, whether the respondent action against the applicant are lawful. First, according to section 1 Clause 2 of Act 559 provide that the Act shall apply to Muslim, which is person who professing Islam. Okay, but there is three applicant, which is the company, non-Muslim, and one Muslim. The first respondent, which is Jabatan Agama Islam Wilayah Persekutuan, act malafide in arresting and prosecuting the third applicant, which is Nik Raina, even though there is no provision under issue by the Home Ministry. Okay. Next, she was not punishable by law in the Sharia High Court because it is infringed in Act 7 of the Federal Constitution. Okay, the second respondent, which is Home Ministry, also act malafide, rushing in order to issue the provision order on the book with carelessly. Okay, the action taken by Jabatan Agama Islam against owner of the bookstore and second appellant, which is Stephen Fang, were not applicable in Sharia laws because their status, which is non-Muslim. Okay, the applicant had succeeded in showing that the respondent to be guilty of illegality, abuse of power, irrationality, unreasonable exercise of power, unconstitutionality, and procedural impropriety. To conclude, the court views that respondent action against the applicant as unlawful. That's all for the case 1.
Okay, so next we're going to move to the next, the second case, which is the Z Publications in Berhad and another versus Jabatan Agama Islam Selangor and others. Okay, so a brief introduction about this case. This case was held at the High Court Kuala Lumpur, and the application is for the judicial review. The judge panel is Hanifah Fariqullah, judge. The judgment date is on 14 December 2016. This case has about two applicants, which is the first applicant is Z Publications in Berhad, and the second applicant is Muhammad Ezra bin Muhammad Said. While the respondents for this case consists of six respondents, which is the first one is Selangor State Islamic Religious Affairs Department, JAIS, highest ranking officer of JAIS, second respondent, and the third respondent is Selangor Chief Religious Enforcement Officer. Fourth respondent is Chief Sharia Prosecutor of Selangor. Fifth respondent, State Government of Selangor, and the last respondent, the sixth respondent is the government of Malaysia. So we're going to move to the facts of the case. So the case, before the case started, is from the May 2012, which is the Z publication. The first applicant had published a book that is considered as contrary to Islamic teaching. The book is entitled as Allah, Liberty and Love, The Courage to Reconcile Faith and Freedom. And the book was then claimed as contrary to Islamic precept. So at the end of May 2012, Jaiz, which is the first respondent, with a search warrant, raided the premise, and 180 copies of the book were confiscated. The company's director, Muhammad Ezra, which is the second applicant, was arrested and taken to the Selangor Chief Religious Enforcement Officer's office, which is the third respondent. And then a statement was then recorded from him. Okay, next, the raid at the first applicant's premise, which is the Z publication, and the second applicant's arrest followed closely on the heels of an order issued by the Minister of Home Affairs. The first applicant then applied for a judicial review against the Deputy Minister of Home Affairs, Minister of Home Affairs, and the Government of Malaysia to challenge the order. Okay, then the leave for judicial review was then granted by the Justice Zaliha bint Yusuf at the High Court, and the court granted it. The respondents then also applied for leave to appeal to the Court of Appeal on 2 October 2013, but then dismissed by the court on 13 January 2015. Okay, next slide. The respondent again applied for leave to appeal to the federal court, and it was heard on 2 February 2016 and granted, but only on one question. And the question is whether the prohibition of the translated version under Section 7, Clause 1 of the Printing Presses and Publications Act 1984 that has been quashed in the circumstances where the prohibition of the original version remains in force is valid in law. Okay, so for this case, there is also another individual professing the religion of Islam, also subjected to the prosecution by the Islamic authorities of the Federal Territory of Kuala Lumpur. The individual is from the previous precedent case, which is from the Berjaya book case. The individual is Nik Raina binti Nik Abdul Aziz. Okay, so one of the parties in that case was charged under the equivalent provisions to Section 16 in the Federal Territories, namely Section 13 of the Sharia Criminal Offences, Federal Territories Act 1997. Okay, next slide. Okay, then the Nik Raina challenged the court against similar action taken against her by the authorities was successful in a decision upheld by the Court of Appeal. So, therefore, the applicants for this Z publication case submitted that this court is bound by the decision of the Court of Appeal for the Berjaya book case and should follow it in allowing the application in this matter. Next.
Now, based on the issue arose in this case, the issue is whether the Selangor State Legislative Assembly had the power to enact the enactment and not whether Section 60 was ultra vires the Federal Constitution. We move to the relevant statute provision. We have 4 relevant statute, which is first, Federal Constitution. There is many Federal Constitution used in this case. Second, Printing, Presses and Publication Act 1984, which is the provision giving publisher an opportunity to show the cause and the reason. Okay. Third, Sharia Criminal Offences, Federal Territories Act 1997. Is provide that the publishers, if they publish contrary to the Islamic teaching, can be convicted to offences. Last, Section 2 of the Sharia Code, Criminal Jurisdiction Act 1965. Provide that jurisdiction shall not be exceeded imprisonment exceeding 3 years, or fine exceeding 5,000 ringgit, or whipping not exceeding 6 strokes. Now we also have case referred to. We have 4 case referred. You can see first Berjaya Book, SDM, PhD and others against Jabatan Agama Islam Wilayah Persekutuan. Second, City Grow against the Government of Malaysia. Third, Jabatan Agama Islam Wilayah Persekutuan against Berjaya Books. And we refer to case Z Publication against Kerajaan Negeri Selangor.
Okay, thank you, Aimai Sarah, for the explanation. So we go to the second last part of the case review on case 2. So the appellant's argument. So the appellant sought a declaration at the federal court in Z publication case that section 16 of the Sharia criminal offences Selangor Enactment 1995 was null and void. Second, the applicant also sought for various consequential reliefs in the form of mandamus, prohibition, certiorari, and damages. Okay, so for the respondents raised the preliminary objection that the court has no jurisdiction to hear the application since the federal court had already decided that section 60 was valid, inconsistent with the federal constitution. So they claim that there is no need that unnecessary for the court to hear these cases, as the federal court has already decided on this particular matter. That's all from me.
Okay, the last one is the ground of judgment. To respond, the issue of the case, as mentioned by Aiman Sarah earlier, which is whether the Selangor State Legislative Assembly had the power to enact the enactment and not whether Section 16 was ultra vires the Federal Constitution. Since the applicant challenged the constitution validity of Section 16 of the Sharia Criminal Offences Selangor Enactment 1995, the impugned section, the judge considered it is necessary to reproduce the same based on 16 religious publication contrary to Islamic law. Any person who prints, publishes, produces, records, or spread any book or document or containing a contrary to Islamic law, or have any book, document, or other form of record for sale or spread it, shall be guilty and liable on conviction to a fine not exceeding 3,000 ringgit or imprisonment not exceeding 2 years, or both. The court may order any book, document, or other form of record referred to in subsection 1 to destroy that no person may have been convicted of an offence in connection with such book, document, or other form of record. The High Court judge also referred to the legal principle as stated Federal Court in the case of Z publication, which is discuss the validity of Section 16 of the Sharia Criminal Offences Selangor, Enactment 1995, the impugned section, and held as follows. It is clearly falls within the scope of precept of Islam and not a matter included in the federal list, and the punishment imposed is within the limits set by Section 2 of the Sharia Courts Criminal Jurisdiction Act 1965. Therefore, it is valid and not otherwise in the Federal Constitution. As Muslim in Malaysia, it is not only subjected to the general laws enacted by Parliament, but also to the state of religious nature enacted by legislature of a state, This is because the Federal Constitution allows the legislature of a state to legislate and enact offences against the precepts of Islam. It is clear that it was the intention of the framers of our constitution to allow Muslims in this country to be also governed by Islamic personal law. For the above reasons, we hold that the imputed section is valid and not ultra-vires the federal constitution. The petition is dismissed. So, it is clear that the federal court had decided that Section 16 of the Sharia Criminal Offences Selangor Enactment 1995 is valid and not ultra-vires the federal constitution. Hence, the relief sought by the application is dismissed. Okay, next. Regarding with relief sought raised by the appellants, the High Court has referred to the legal principle laid out in the preceding case, which is city growth against the government of Malaysia. Based on the above reasons, the preliminary objection is allowed and hence judicial review is dismissed with no order as to cause. That's all from us. Thank you.